So, welcome to my channel, people. Here's the thing. A lot of individuals out there like to exercise the right to bear arms, the right to travel, and you are 9 times out of 10 unsuccessful. And that 1% that are making it are the ones that actually, trying certain avenues. But sometimes it's not the people that's trying to exercise their rights. Some of these times are the judges. These judges are idiots. A legal definition for idiot is somebody that basically doesn't know what's going on. There's a court case, I can't remember it, I haven't found it, but it's a rumor that once you're considered an idiot, you can't be prosecuted. But that's a whole different theory and whatever, forget that. Alright, so this is just to educate everybody on both sides. And I just want to state that there's this case called Ex parte Young. Ex parte Young is to get equitable remedy, but in the future as a prospective relief. So all of us are usually exercising our rights, and then we're getting arrested and going to jail and having to defend ourselves, and you're going down. Sometimes you gotta win an appeal. It's a headache and it's bad. So what you want to do is you want to start a court case in where you would go, instead of using like 42 USC 1983 or similar actions in that nature, yours is gonna say Ex parte Young. It is a Supreme Court case in where I believe it was some individuals were preventing the government from enforcing certain rights because the rights were unconstitutional. So in this case, if you feel you have a flawless right to travel argument, you want to put it on the Ex parte Young. You go to the federal court and you sue them. For example, you're going to sue the governor or the mayor or the DMV officer, because the DMV officer is the one that keeps your records for when it comes to your license. So what you want to do is you go on the Ex parte Young. You are the plaintiff. The defendant is going to be what's the name of this defendant? The defendant is going to be the commissioner of the Department of Motor Vehicles.
Continue for 3/4 mile.
The commissioner of the Department of Motor Vehicles in your state. Usually they have different names. Some are similar, like Department of Motor Vehicles. Some have Department, it's different names, but it's still Department of Motor Vehicles from the state. So you go to the Ex parte Young, you submit your argument in there. The defendant is going to be the commissioner. So now when you sue them, obviously you gotta serve the plaintiff. You gotta serve the attorney general. You must always include the attorney general whenever you're challenging a state law as unconstitutional, or it somehow violates your constitutional rights. You always have to notify the attorney general, or your case will be dismissed. And when you file in federal court, you are not going to be filing under...
Go past this light. Then, at the next one, turn left onto 75th Street, Bay Ridge Parkway.
You're not going to be suing them under your state. You're going to sue them under the federal rules of civil procedure. So disregard the state rules of civil procedure. Go with the federal rules of civil procedure. You're usually going to file in the district court. And this is called Ex parte Young. You guys want to look it up. So I don't know, a lot of people doing it out there, not doing it, man. I found this in due diligence. There's a lot of people that are very aware of this but have not utilized it. Most of them are state governments that do it, because they got to be on top of stuff. So you go to Ex parte Young, and you're going to sue for prospective relief. You go on your claim, you could be like, this claim is also under 42 USC 1983, which is, deprivation of right and the color of law. Then you also want to include, what's that thing called? 18 USC 241 and 242 for conspiracy and for deprivation of rights. Now, these are laws that you can use, including habeas corpus for immigration cases. You know, but that's a different issue. But yeah, man, look up into it. Young, you know, don't go to jail, don't get arrested. So sue them ahead of time. Say, listen, this is the law that they're gonna lock me up for, which is, let me say, failure to have a license, which I'm not sure the code or what it is in your state, or failure to provide insurance, or failure to register your car. So use all three of them. Then you're gonna sue them on the ex parte Young. You put the commissioner as the defendant. You put defendant/respondent. And then there's no remedy there except for an injunction. You could get a permanent injunction, but remember this: it's only what they quote, and I quote, you know, with commas, ex parte Young. I'm bugging out. I'm sorry. As applied. So as applied is that it only applies to your situation. It doesn't apply to anybody else's situation. So even if you win, even if the law gets struck down as unconstitutional and you get an injunction, that's only for you or the plaintiffs in your suit. It does not apply to me. So say I'm suing the court, right? I'm suing for under the Second Amendment, that I'm stating that all CCWs from the state are unconstitutional. I would say all penal law section 400 is unconstitutional, and what other section? So it's usually three sections. It's the Safety Gun Control Act, something like that. You know, you got to write it down because there's a lot of stuff to be learned, and you just want to make sure you know the basics, which is how to enforce the Constitution, and then whatever they charging you with, then you use that. You know, but yeah. So say mine would be like United States Supreme Court. No, United States District Court, Eastern District of New York. Is gonna be, I'm the plaintiff. The defendant is gonna be, in my situation, I would go against the governor because that's the chief executive. You know what I'm saying? So he's like a judge, but that's crazy. How can an executive officer be a judge, right? Well, you gotta understand, he overrules decision of judges. He could pardon you. That's the governor I'm talking about. She could pardon you. She could vacate your sentence. She could overturn it, and the judicial function, you know. And they say, you know, it's crazy, but whatever, you know, you just gotta learn how to exercise this stuff. So my guy. So I go, say for example, I'm suing the governor. Me versus the governor. I'm gonna put the date, time, and place, and you would write prospective relief. The state is enforcing unconstitutional laws as applied to me, and is gonna create imminent and permanent damage that will be unable to be reached later. Now, just knowing ex parte Young, you cannot sue for previous harm. So you're gonna be waiving that. That's gone. So a lot of people that sue under that statute or under that case law, if you have previous injury, that's waived. You can't use it. It's gone. It's finished. Fine. Whatever. But there's always ways to go about it. So it will be me against the governor. I'm suing under the Second Amendment and Article 6, Paragraph 2, which is known as the Supremacy Clause. And we are applying that via VIA, which is like through a tunnel, through a channel, through this way, through the 14th Amendment, because we're on the state. So we got to include the 14th Amendment. You know, we got to incorporate it in there just in case it ain't incorporated. You know, so I'm suing them. I'm telling them, hey, listen, Article 400 of the Penal Law of New York, the Safety Gun Control Act of New York, and Section 265 of the Penal Code of New York, as applied, remember, as applied is only to me, it's unconstitutional, and its laws enforced by the state of New York and will cause imminent injury or harm that would be unable to be redressed. So whatever, we go, we sue. Then when they say, hey, this applies to everybody, you're gonna be like, well, that's applied to me. I got the Second Amendment. I got the right to bear arms. And Marbury versus Madison says that anything contrary to my Constitution is null and void of law. And my constitutional right is the Second Amendment, which overwhelms the state law. Because Murdoch versus Pennsylvania clearly states no state, including New York, may convert a secured right into a privilege and issue a license and a fee for it. And if they do convert my right into a secured privilege and issue a license and a fee for it, Shuttleworth versus City of Birmingham, Alabama clearly states no state may convert. No. Sorry, I'm talking too much here, but I'm just trying to get the point across. So, well, Your Honor, I am so-and-so here before this honorable court. I'm standing as my own counsel. I have appointed myself my own attorney, and I'm ready to proceed with my administrative and procedure matters. And at this time, Your Honor, we're moving for an injunction, permanent injunction, against this, the governor. All right, I know I keep stopping and stuff, but here's the thing. Here's the most important thing. When you sue on the ex parte Young, the state of New York is not a party. The state is not a party. The United States is not a party. They're not a party. 100% they're not a party. Because if you sued the state of New York, then